Welcome back to Homo Non Grata, the series that shows and tells how America's gay people weathered the Cold War. Today we're going on a road trip with a couple guys who got themselves in a little trouble in a tiny New Mexico town, and then got into a whole lot more trouble when their private lives were exposed. It ends well for them after a long, hard struggle. This is one of those rare victories I promised. But unfortunately, the legal precedent they set didn't do a whole lot of good for anyone else. This is a case that's made the rounds among legal scholars for the judicial decision, but I don't think anyone's ever looked into just who these people were or what their story is. Till now. I'll say it one more time, you're not going to hear about this one anywhere else. This is Chapter 12, Baser Than the Practices of Pagans, Boys Behind Bars in New Mexico. Fred Bennett and Ernest Britton wanted a better life. Nothing had come easy for either of them so far. In the spring of 1951, they gathered their meager belongings and struck out on old Route 66, as so many others had done before them, and many more would in years to come. But they were heading in a direction opposite to the usual flow of traffic. The West Coast hadn't worked out for these two as they'd planned. They had their sights set on a new life somewhere to the east. Their journey would veer off on a years-long detour that would lead to a rare and hard-fought victory and figure into one of the earliest American efforts to end the legal persecution of homosexuals. Bennett, 22, had been in trouble with the law from an early age in his hometown of Danbury, Connecticut. He was an archetypal bad boy with a lengthy police record that included burglary, car thefts, and escapes from 2 correctional institutions, but no history of violent crime. When he wasn't locked up somewhere, he bounced between the east and west coasts. He'd served time at juvenile facilities, work camps, and state prisons in Connecticut, California, and Nevada by the time he turned 18. With only a 6th grade education, his file with the Connecticut prison authorities noted he liked to read but could do little else. He was said to be a good worker and a well-behaved inmate who got along with his fellow convicts and was disciplined only for distracting them from their work by talking and laughing boisterously. But his social profile labeled him an unstable individual. The words shifty and a wanderer were added, but later crossed out. At 21 years old, he'd never held a job in the outside world. He hadn't been out of custody longer than 4.5 months since age 14. With each new arrest, he'd list as his occupation whatever his work assignment had been at the previous institution: railroad worker, construction worker, printer. His mugshot showed a square-jawed, rakishly handsome young man. It was the type of photo that today would be passed around the internet to break hearts all over the world. In May of 1950, Bennett was free and holding down his first real job at a Chinese restaurant in San Fernando, about 20 miles northwest of downtown LA, when he discovered he was wanted in Connecticut. Only 2 months before his probation period was done, he'd left his home state without the permission or knowledge of his parole officer and was declared a fugitive from justice. He turned himself into the San Fernando Police Department in the hope of having his final probationary months transferred to the California Parole Board, but the Connecticut authorities ordered he be returned there to serve the remaining time in the state prison, plus 3 added months for violating his conditions of parole. He was released from the Connecticut State Prison on Christmas Day and quickly headed back to San Fernando. Ernest Britton's early life hadn't been as colorful as Bennett's. He was born in Burbank, California, and raised in Tujunga in the San Fernando Valley. At 18, he entered the Army and was promoted to the rank of sergeant while stationed at Fort Ord on Monterey Bay, some 300 miles up the coast from LA. Britton went AWOL in May of 1949, just 2 weeks before his 20th birthday, along with a stolen checkbook and another young soldier, William McLean. They traveled to Oregon and wrote bad checks totaling more than $100 at supermarkets and stores in Eugene, Grants Pass, and finally Medford, where they were arrested at the Greyhound bus station. McLean was turned over to the county juvenile officer when he was discovered to be only 15 years old. He'd lied about his age to join the service. Britton was convicted on a forgery charge and sent to the Oregon State Penitentiary, where he spent the next 14 months. At the end of October 1950, Britton was released. He returned home to the San Fernando Valley, and in early 1951 he linked up with Bennett. The two decided to head east together, with very little cash on hand and no known plan in mind. By April 5th, they'd made it as far as San John, New Mexico, 1,000 miles from the Pacific and the last town before the Texas border. It was a dot on the map that existed mostly to provide traveler services: food, lodging, gasoline, and auto repair. Hungry and short of funds, the two decided to break into the local market for a free meal, cigarettes, and a new pair of shoes. They were arrested within 15 minutes and taken to the county jail in Tucumcari. Bennett and Britton were found guilty of burglary in Kay County District Court on April 26th and sentenced to a year in jail. The judge suspended the last 8 months, so they'd be spending only 4 as guests to the county. That still left them with a lot of time to kill, and they were determined to make the best of it. They managed to find a way to pass the night. 3 weeks later, on the morning of Thursday, May 17th, the two were rousted from their cell by the sheriff and told they were going to court without any explanation of what was happening or why. They were hustled into the elevator and taken downstairs. Before being brought into the courtroom, the sheriff asked if they wanted to wait. "Wait for what?" Bennett snapped back. "Let's get this over with." This outburst would later be cited by the state of New Mexico as waiving their right to an attorney. With no counsel to represent them and no preliminary examination, Bennett and Britton were arraigned on a charge of sodomy and ordered to enter a plea. They had no knowledge of either the sodomy law in New Mexico or the penalty for those convicted. The maximum was life in prison, and they were unable to call witnesses on their behalf. Both men entered guilty pleas. Both were sentenced to the New Mexico State Penitentiary in Santa Fe for a term of not less than 5 and not more than 15 years. Homosexuality was considered to be a serious problem for both male and female inmates at all penal institutions, from juvenile facilities to state prisons. Alarmists claimed that in some places up to 60% of the population was engaging in sex with fellow inmates. When prison reforms were discussed, measures to curb homosexual acts were always at the forefront. Segregating deviants from the rest of the population was said to be essential, as was segregating young, first-time offenders from hardened criminals who'd make them easy prey. Few of these measures were taken. With no funds for enacting reforms, large institutions had no choice but to accept the situation and look the other way. But at smaller jails like the one in Kay County, local officials aggressively prosecuted anyone found to be indulging in immoral forms of recreation. As prisoners of the state, Bennett and Britton made use of legal resources that hadn't been available to them in Tucumcari. They found an attorney who prepared a writ of habeas corpus, claiming they were illegally deprived of their liberty due to the improper proceedings in Kay County. They petitioned the U.S. District Court in Santa Fe, but were instructed to first pursue their case at the state level. They appeared before the Santa Fe District Court in September of 1952, but the writ was denied, and the New Mexico Supreme Court discharged the case without a hearing on the claim that they'd failed to present grounds for overturning the lower court's decision. Once again, an application was filed with the U.S. District Court in Santa Fe, but the judge ruled they hadn't yet exhausted all of their state-level options. The weeks ticked by, and Bennett and Britton remained behind bars. In October, their attorney, J.H. Bertram, filed a new petition with the New Mexico Supreme Court, this time attacking not only the Kay County legal process, but the validity of the sodomy charge itself. The court chose to hear the case. The hearing was scheduled for November 15, 1952. New Mexico's sodomy statute was among the most cryptic in the nation, stating only that every person convicted of the abominable crime of sodomy committed either with human being or with any animal, on conviction thereof, shall be imprisoned for not less than 1 year or fined in any sum not less than $1,000, or by both. The act that constituted the crime was not defined in any way. The statute merely specified the penalty to be given a person who was convicted of it. Complicating the matter further was that Bennett and Britton had been caught in an act of oral sex. With sodomy remaining undefined, Bertram argued that the court had no choice but to default to the common law meaning of the word. Well-established American legal references agreed that English common law defined sodomy as pertaining to anal sex alone, and high court decisions in several states had been made in accordance with this finding. Where a state Supreme Court had decided to the contrary, Bertram pointed out their statutes contained some type of language, if only in general terms, that permitted a broader interpretation. Even the antiquated crime against nature verbiage allowed the court more leeway. In no case where a statute defined the penalty alone and not the act had a high court ruled that oral sex between men constituted the crime of sodomy. Responding to the writ for the state of New Mexico was Assistant Attorney General Willard F. Kitts. His argument opened with an admission that the sodomy statute was vague, and clear definitions of the act in legal texts were virtually non-existent. He then proposed that the correct interpretation of the crime could be ascertained if the court were to approach the subject carefully and logically, a statement that virtually assured his argument from that point on would be neither careful nor logical. Kitts maintained there were two definitions of sodomy. One he called sodomy proper, which specifically referred to anal sex. The other was sodomy as a generic term or in its broader meaning, which apparently encompassed all sexual behavior frowned upon by society. It is obvious, he claimed, that the statute seeks to cover much more than sodomy proper and was intended to use sodomy in its broadest sense. To prove his point that this interpretation was in the minds of the New Mexico legislature, Kitts noted there was no stellate prohibiting fellatio. Since in his mind fellatio must be illegal, it was obviously covered by the sodomy statute. His celebrated logic seemed to run in circles. As for the improper proceedings in the Kay County Court, Kitts conceded that if oral sex was indeed not covered under the sodomy law, the lack of legal counsel would have put Bennett and Britton at a substantial disadvantage. He argued, however, the Kay County judge may not have been aware of the specific act committed, since both the indictments and the information provided by the prosecution simply charged both men with sodomy. This was an extraordinary position to take. In essence, he was saying the judge should be excused for depriving the defendants of their rights because he didn't understand the charge against them. The Supreme Court didn't buy it. On February 13, 1953, their decision was given, written by James C. Compton and unanimously supported by the other four justices. The ruling of the court was that New Mexico's sodomy statute did not apply to acts of oral sex. The remaining issue was that Bennett and Britton had pleaded guilty to the crime. This would serve as an admission of having committed whatever acts were specified by the prosecution, as long as the plea was made voluntarily and with full understanding of the charges. Since there was no description of the acts that comprised the crime in either the statute or the charges filed, the court found their guilty pleas couldn't have been made with full knowledge of what they were admitting to. It was noted as well there was no credible evidence that the two had been informed of their right to counsel or had waived that right. The court didn't condone the act that had occurred. Justice Compton's written opinion was more than crystal clear on that point. While the acts admittedly committed are even more sensual and filthy than the offense charged, baser than the practices of pagans, we cannot extend the crime of sodomy so as to include acts called fellatio. Here, as in various other courts around the nation, copulation per os, by mouth, was considered to be more indecent and more disgusting than copulation per annum, the other orifice. The phrase sensual and filthy is particularly telling. It implies sensuality in and of itself as something immoral and wrong. If it feels good, it must be bad. This attitude lends weight to the claim made by some authors of the day that American society wasn't so much anti-homosexual as it was anti-sexual. The act of sex was a shameful thing, tolerable only as far as it was necessary for reproduction. Homosexuals were particularly hated because their acts were purely hedonistic, without the validation of a procreational purpose. Statutes that banned oral sex, even between straight people, married or not, were essentially intended to prohibit men and women from enjoying themselves. By New Mexico law, however, the justice's obligation was plain to see. The court ordered the men to be released. Bennett and Britton had been in custody for a total of 22 months. It's somewhat disappointing that the last 3 had passed while the court was making up their minds and putting pen to paper. No compensation was offered for the 1.5 years they were held in prison above and beyond their original sentence for committing an act that wasn't against the law. The court closed the proceedings by recommending new language for the legislature to amend the statute and define the crime of sodomy in a way that explicitly applied to both anal and oral sex, copied directly from the U.S. Army's Manual for Courts-Martial. In the post-war years, the mindset instilled during World War II and perpetuated by Korea had been that military discipline should serve as a model for civilian life as well, all the way down to the haircuts. But the Uniform Code of Military Justice, established by Congress in 1951, was developed with the idea that the standard of behavior for fighting men should be higher than that expected of ordinary people. The commanding officer might not want his men trading blowjobs with each other, but such an attitude should have no particular relevance to a general population who weren't billeted in a barracks with random strangers, and weren't expected to snap to attention or follow orders on command. As soon as the court's decision was made public, a bill was introduced in the New Mexico State Senate to adopt the recommended language. The bill easily passed in the Senate but failed in the House of Representatives, who may not have been quite ready to curtail their own sexual behavior. Without a statute defining the acts that constituted the crime, and in view of the New Mexico Supreme Court's ruling, many legislators proclaimed that the state did not have an enforceable law against sodomy of any kind. In February 1955, 2 years almost to the day after Bennett and Britton were freed, a bill was once again introduced in the New Mexico Senate to amend the sodomy statute. Attorney General Richard Robinson had requested the bill, and State Senator Gene Lusk of Eddy County in the far southeast had authored it, on the claim that the state Supreme Court had reversed a number of sodomy convictions because there was no law on the books. In truth, the court had heard only one sodomy case since the Bennett and Britton decision, involving a man having sex with a dog, and they'd upheld the conviction. The assertion that no sodomy law existed seemed to have been either a misconception or a politically motivated ruse, repeated at face value by the Santa Fe and Albuquerque press to compel the passage of a bill that would outlaw oral sex. This time the measure passed unanimously in both the Senate and the House. Governor John F. Sims signed the bill into law on March 8, 1955. The amended text of the statute was identical to that of the earlier bill that failed, and had been copied verbatim from the recommendation by Judge Compton in 1953. Sodomy consists of a person intentionally taking into his or her mouth or anus the sexual organ of any other person or animal, or intentionally placing his or her sexual organ in the mouth or anus of any person or animal, or coitus with an animal. Any penetration, however slight, is sufficient to complete the crime of sodomy. Both parties may be principals. As before, the penalty was defined to be a minimum of 1 year in jail and/or a fine of $1,000. No maximum was defined for either the amount of the fine or the prison term. It is a testament to the level of sexual repression in America that as late as 1955, with the chance to start over from a clean slate, the New Mexico State Legislature chose to prohibit both oral and anal sex even between straight married couples, punishable by up to life in prison. The amended statute still contained a considerable gray area in the case of cunnilingus. While an attempt was obviously made to include all oral acts involving his or her sex organs, the requirement of taking into or placing in the mouth such organs would seem to pose an anatomical puzzle. It's astounding that a body of 87 fully grown, presumably sexually experienced men would be incapable of looking that far ahead. If the disconnect arose from ignorance or a failure to comprehend the fundamental nature of the act, then it certainly speaks to the steadfastness and perseverance of their poor neglected wives. 5 years later, in January of 1960, New Mexico became the very first state to attempt a repeal of their sodomy law altogether. Homosexual acts between consenting parties 16 years of age and older would become legal, unless those who performed them were confined in a penal institution. Legislators who supported the change felt the statute had caused more than its share of trouble for no good reason. The measure passed a vote in the New Mexico House, but the state's Legislative Criminal Law Study Committee killed it. New Mexico wouldn't legalize sodomy until 1975. The decision of the New Mexico Supreme Court in the case of Bennett et al. V. Abram has been cited in a number of court opinions in the state and elsewhere as an example of a strict interpretation of the letter of the law. This was how American justice was supposed to work, and for the most part how justice did work, except in the matter of sex offenses. In that one area of law and no other, legislators intentionally wrote vague and ambiguous statutes, and jurists allowed defendants to be prosecuted without explicitly specifying the charges, all in the name of maintaining delicacy and preserving courtroom decorum. As a result, in most regions of the nation, but thankfully for Bennett and Britton, not in New Mexico, high court decisions in homosexual cases were as often decided by the court's personal biases as by any piece of legislation enacted by due process elected officials. Ernest Britton returned to California and moved north to the town of Marysville in the heart of the state's gold country. A motorcycle enthusiast, he worked at a Harley-Davidson shop, remained single, and eventually retired to Ogden, Utah, where he passed away in 2004. Fred Bennett returned to Danbury, Connecticut, where he'd find a career as a driver. He went straight, in police terminology, and spent no more time in jail. After 2 brief abortive marriages, he entered a third in the mid-1960s and settled down with a woman who'd be his wife for 45 years and the mother of his 3 children. In true bad boy fashion, he didn't get around to divorcing his previous wife until 1978. Bennett remained in Connecticut for the rest of his life and passed away in 2009. Well, that's it for today. Next time we'll take a look at an incident that by all rights should be recognized as a major event in LGBTQ history. A massive riot for gay rights, 6 years before Cooper's Donuts in LA, 13 years before Compton's Cafeteria in San Francisco, and 16 years before Stonewall in New York. So why have you never heard about it? Well, because nobody's ever taken a good hard look at what it was all about. Till now. You're going to see it here first. Don't miss it.